It's like coming to a judge. Fuck. It's just a failure to realise the people that
Appeal in the matter of Carey Street Investments Ltd and another, and Brown and another, has heard.
Mr. Norbury.
Good morning, my lords, my lady. Just a small point of housekeeping. My learned friend Mr. McCourt Fritz and I have discussed, and his minimum time required is 1 hour 45 minutes. So if we get to 12:30, don't let the cortisol levels rise too high, because he and I have agreed that I can go on, if necessary, until 12:45, unless the court objects. I hope to be done still by 12:30, but we haven't set that hard deadline between us. Yesterday I had got to paragraph 123 in the judge's judgment, and I just need to make some final remarks in relation to the findings about the transfer at an undervalue as alleged on New Court. And I want to start by moving on to paragraph 124. That is at page 118 in the call bundle behind tab 7. The judge explains that in cross-examination, Mr. Brown accepted the Bucking were not valuation experts. However, as he points out, they were nonetheless property specialists. In these circumstances, it does not, in my view, follow, as the claimants have suggested, that Mr. Brown could not have honestly believed that the transfer price was an appropriate market value for the purposes of the transaction. I'll come in a moment to the and versus the, but I suggest here that what this is being said in the context of a negative. So he's saying the claimants have said, because Mr. Sirra has given you the figure, it's not an appropriate market value. And so what the judge is saying is, I don't agree that it's not an appropriate market value. That doesn't mean that the judge thinks that there's any number of market values, or that Mr. Brown thought that there's any number of market values. And then keeping with the judgment over the page 125, and dealing now with one of my learned friend's attacks on material that the judge is alleged not to have taken into account. Mr. Parker draws attention to the 2004 accounts for CSI, which Mr. Brown signed in September 2005, approximately 6 weeks after the transfer of New Court. As I've mentioned, those accounts contained a note to the effect that the directors believed the value of New Court to be in excess of 65 million. However, in my view, little can be read into this. Mr. Brown clearly could not recall his thinking and the circumstances in which those accounts were signed. As noted above, Mr. Sirra was asked to comment on the value used in the accounts, and it is to be inferred, approved the proposed wording. Given that the concern in relation to the accounts clearly related to the Project Ocean borrowing, the statement in the accounts is perhaps not surprising given Mr. Sirra's apparent use of a range of values. It does not therefore follow from this that Mr. Brown must have thought that in July 2005, when the transfer took place, a figure of 65 million was below the market value of New Court. So the judge there very clearly has in mind that what Mr. Brown should be considering is the market value, and whether or not what is being put forward as a market value is below the market value. In other words, it's the market value in my submission, just as a matter of construction of what it is reasonable to read the judge as saying. The judge also takes into account that the documentary makes clear that it was anticipated following the hive up of New York to NCP and the subsequent refinancing, which took place shortly afterwards, CSI would be put into solvent liquidation. Taking this into account and looking at the interests of the members of CSI as a whole, this reinforces my conclusion. Reinforces being the key word there. That's not the sole basis of the judge's conclusion, but it reinforces the judge's conclusion that Mr. Brown did not believe that his actions were contrary to the interests of CSI.
Does that fit into how the case was being approached? I mean, as you explained yesterday, the focus was on dishonesty, not on breach. If you see what I mean.
I do, my lord, yes.
This point might bear on breach, but that wasn't really in play. So, as I understand it, it was really common ground that what mattered was whether Mr. Brown had thought that this was the market value.
That is true, my lord. All I would add is that what I say the judge is doing here is taking into account the fact that Mr. Brown thought no one was going to be prejudiced. And that is consistent with his finding that Mr. Brown understood in his mind that this was an honest enterprise. The package of measures relating to the hive-up was honest. No one was going to be prejudiced. And so it merely reinforces the conclusion that it's the market value that has been selected. When the judge is thinking about Mr. Brown's state of mind, the judge is saying, no one was suffering here. There's no victim in Mr. Brown's mind. Now I'm going to, it may appear to be out of turn, but I'm going to go straight on to blind eye knowledge, because in fact, I'd suggest that the judge's findings on blind eye knowledge also inform how one should view what the judge found about actual knowledge. So 128, as I've explained, in order for Mr. Brown to have blind eye knowledge that he was acting in a way which was contrary to the interests of CSI, it must be shown that he had a firmly grounded suspicion that New Court was worth more than 65 million, and that he deliberately refrained from taking any action to confirm his suspicion. Again, just pausing there, the judge has firmly in mind that what matters here is whether or not New Court is worth more than 65 million, and therefore whether saying that New Court is worth 65 million, which is what Mr. Brown did for these purposes, is a statement about market value. I have already found that Mr. Brown was aware of the possibility that New York could be valued at a price in excess of 65 million. The property was, for example, shown in the R&R asset statement at a value of 70 million. In addition, the clear purpose of the Project Ocean refinancing, as far as New Court was concerned, was to increase the level of borrowing, which would in turn be dependent on New Court being valued at 65 million. I would accept on this basis that Mr. Brown's suspicion was firmly grounded on specific facts known to him. Now, before we continue, I ask the court to bear in mind what the judge has previously said about Mr. Brown's appreciation of different values for different purposes. And it's with that in mind that in my submission that the judge goes on to say, however, I reject the suggestion that Mr. Brown deliberately refrained from arranging for CSI to obtain an independent valuation for fear that this might confirm his suspicions. On the contrary, the documentary evidence makes it clear that it was always intended that a valuation should be obtained to support the 65 million value. Pausing there again. In my submission, that is a reference back to the material that I took the court to yesterday, rejecting the defendant's respondent's case that the DTZ letter, which was being sought after the board meeting, had in fact been at the board meeting. And what the judge says is they were seeking confirmation of the valuation that had been used at the board meeting. Now, although the judge does not say that in terms, in my submission, it's the only reasonable interpretation of what the judge has in mind here. Olswang had advised numerous times in advance of the transaction that such a valuation would be needed. It is the very thing that Miss Akel was asking Mr. Sirra for in her email of the 26th of July 2005. Although it appears that it was never finalised, there can be little doubt that this is exactly what the DD said letter was intended to be. Claimants invite the court to infer that Mr. Brown made a deliberate decision not to obtain an up-to-date independent valuation in advance of the transaction taking place on the basis of nothing more than his suspicion that a higher value for New Court could be justified. Given that the claimants can point to no other evidence justifying such an inference, and that what evidence there is points in the opposite direction, it would not, in my view, be appropriate to make such an inference. The reality is that Mr. Brown considered that a value of 65 million was justified based on his team's discussions with Buckingham. The question of obtaining independent supporting evidence was left until later. So I'll deal with the blind eye knowledge point in just a moment, but just the final point on actual knowledge. The question is this: did the judge find that Mr. Brown thought that he was telling the truth when he said to HMRC, this is the market value? And in my submission, having reviewed the entirety of the judge's findings on the transfer of New Court, there can be no doubt at all but that the judge's answer to that question was yes. The judge thought that Mr. Brown was behaving honestly when he put this figure forward. And that's because he thought it was the market value. That is to adopt my Lord Justice Popplewell's delineation of the last couple of days. That's the jury question. Did Mr. Brown believe what he was saying? Or what he knew he would have to say? And there's no doubt at all in my submission that the answer to that is yes, in the judge's judgment. And so I can wrap up my submissions on blind eye knowledge, which is the third ground that my learned friend relied on. I'll come back to the second ground, obviously, very quickly. Because on the basis of the judge's overall findings on knowledge of New Court, there's simply no question of a deliberate aversion of a gaze, which is what's required for blind eye knowledge. It very clearly follows from the judge's primary findings of fact that there was no blind eye knowledge, notwithstanding suspicion that the judge found. And a similar point, although there's not the same evidence of intention to get a specific valuation, but a similar point clearly underlies the judge's thinking on blind eye knowledge in relation to Ludgate House. And we can see that at paragraph 254 at page 144 of the Bible. We see there that similarly, the judge accepts that Mr. Brown would have had a suspicion, but that there is simply no evidence that Mr. Brown consciously refrained from getting an up-to-date independent valuation. for fear that it might confirm suspicion. On the contrary, he was told that valuation advice had been obtained from Buckingham, and he relied on that advice. And then, I won't repeat what I said yesterday, but it was at this point that my learned friend is forced to speculate as to what Mr. Pollard told Mr. Brown, and to speculate that he told him something that made Mr. Brown doubt that he could honestly say that the value was the market value. But there's just no basis for that, remembering that Mr. Brown was not involved in the background to the decision. So those are my submissions on the transfer at an undervalue, both in relation to knowledge and blind eye knowledge, which is the first and third grounds. Supposed to move on to the second ground, which is the other alleged dishonesty that was ignored. Now, I've sought to deal with some of these points in passing, because my overarching submission that what's important here is to see the judgment as a whole and not to do what my learned friend does, which is to take phrases out of context and say that then the judge didn't have in mind all the other points which the judge did have in mind because they're mentioned elsewhere, but he doesn't refer to again when he comes to make his final ruling. Now, the bedrock on which this submission is built, the submission of my learned friend, is that the judge took the issue of motivation to be determinative because the judge said that in the circumstances it was inconceivable that Mr. Brown would act dishonestly. It is said that the judge simply didn't go on to consider the question of honesty properly. Now, as my Lord Justice Newey mentioned yesterday to my learned friend, that excessively literal interpretation of the judgment is, in my respectful submission, obviously wrong. It's obviously wrong to say that the judge closed his mind to whether there might be other evidence of dishonesty. Because what my learned friend is really saying is that when the judge came to consider my learned friend's submissions on other points that my learned friend says show dishonesty, the judge found against him. It's not that he didn't consider them, he considered them on their merits, but he had in mind Mr. Brown's motivation. And that's right, I don't think it's in dispute between us. The judge found that the Bank of Tokyo and Mitsubishi case, which points, obvious as a matter of human nature, points to the relevance of motivation as a factor that the court should take into account. The judge did that, and it's simply that his conclusion on that can, if taken out of context, be interpreted to mean that he attributed excess weight to that point. But in the judgment as a whole, there's simply nothing to support that, because it's obvious he did consider all the individual allegations of dishonesty. I'm just making that good by going back briefly to what the judge says. It's at page 120 of the judgment, from paragraph 133. The judge starts by pointing out that it's relevant to take into account motivation. And then at 134, it's not suggested that Mr. Brown stood to benefit personally. Instead, what's suggested is that what motivated Mr. Brown was a desire to assist CSI to evade tax. Whilst I would accept that a professional person as Mr. Brown may be keen to help their clients achieve their objectives, as Lord Millett observed, a charge of fraud against independent professional trustees in the absence of some financial or other incentive inherently implausible. But the judge fairly goes on to point out that experience has shown that that's just because it's implausible doesn't mean it never happens. exercising his judicial balance, I would say the judge then points to the fact that Mr. Brown was an employee. He was also a director, but no evidence that he shed in any profits. And at the time of the transfer of New Court, he'd only been responsible for the structure for a few months. He cannot have had any experience the client would follow him were he to move elsewhere. The conclusion is confirmed by the fact that not long afterwards, responsibility for the relationship passed to Mr. Pollard. In the circumstances, it is, in my view, inconceivable that, as suggested by the claimants, Mr. Brown would put his career and his reputation on the line for the client by dishonestly assisting to evade tax. And then, 137, in determining where the probabilities lie, an examination of Mr. Brown's motivation supports my conclusion that Mr. Brown did not act in a way which he knew was contrary to the interests of CSI. So it supports the judge's conclusion. It's not the premise on which he rejects all submissions that Mr. Brown acted dishonestly.
Was it the submission by the claimants that it was Mr. Brown's motivation to personally benefit from the association with the client or the client moving with him, or is this simply something that the judge is considering as a possibility and rejecting?
I believe I'm right in saying that this is just the judge considering this as a possibility and rejecting. I don't believe there was a positive case put forward. It was the defendants who were relying on motivation, not the claimants. The defendants were saying, look at motivation as one of the factors here. We said, what's in this for Mr. Brown? Would he really, as a regulated professional whose whole business depends on not having findings against him, would he act in this way? And so in that context, I'm not going to spend a lot of time going back through the minutes. The court has my submissions on why the minutes were not dishonest. I will deal briefly with the second supposed example of ignored dishonesty, and that relates to Sampson House. And the judges said not to have taken proper regard of the alleged dishonesty in relation to Sampson House. The judge dealt with the particular point at paragraphs 80 to 82, which is at page 109 of the judgment. Again, an example, I would say very obviously, of the judge considering carefully what Mr. Parker had to say below. Paragraph 80, Mr. Parker drew attention to one part of Mr. Brown's evidence in the proceedings, which he says must have been untrue. Just pausing there, obviously what would matter here is for it to be deliberately untrue. This relates to a certificate of solvency relating to APL, which Mr. Brown says was signed after seeing a balance sheet confirming that APL would remain solvent after transferring Sampson House to APL's parent company at a price of 148 million. In fact, the balance sheet, which was subsequently produced to the court and which forms part of the evidence in these proceedings, shows Sampson House at a value of 150.5 million, on the basis of which the net assets of APL were approximately 2.1 million. The transfer of Sampson House at a value of 148 million, being 2.5 million less than the recorded value, would therefore have rendered APL insolvent. As Mr. Parker points out, Mr. Brown had no explanation for this, other than to suggest that perhaps there might have been some other balance sheet for APL showing different figures. Mr. Brown was not, of course, cross-examined in the Angel Miss proceedings, as it was only a summary judgment application and not a full trial, and does not in any event necessarily follow that just because a witness has given untruthful evidence in one set of proceedings, their evidence in another should also be presumed to be dishonest. As I have said in these proceedings, my conclusion is that while Mr. Brown's evidence was unreliable, it was not dishonest. So the first point is, it's clearly taken into account. It's not plainly wrong. So with the greatest possible respect, this court should not be interfering with that review. But more than that, I would suggest that it's obviously right. Mr. Brown was not cross-examined in the Angelmist proceedings, and so what that means, and what I suggest the judge is saying here, is that I don't know whether he was lying or not in the Angelmist proceedings. So that's his first stage. He doesn't actually quite spell that out. He says, Mr. Brown was not, of course, cross-examined in the Angelmist proceedings. It was only a summary judgment application, not a full trial, and it does not in any event necessarily follow. But there's it's obvious, but it's not stated, that what the judge is saying is, so I don't know whether he was lying in Angelmist. And let's just think about that a little bit. We're talking about a judge in 2023 making a conclusion about a cross-examination in 2023 of a statement made in 2013 about events that took place in 2006. It would be ludicrously unreliable to make a finding about the honesty with which the 2013 evidence was given. Maybe Mr. Brown made a mistake in 2013. Maybe he failed to review his witness statement properly in 2013. Maybe he had a good explanation in 2013 about what had happened in 2006 that he simply couldn't remember in 2023. We don't know what Mr. Brown actually had in mind when he signed the balance sheet. Mr. Brown didn't know what he had in mind when he signed the balance sheet some 17 years before, or 18. And my learned friend says, well, this is evidence of signing documents without a belief in their truth. Well, maybe, maybe not. We just don't know. And I think under questioning from the court, my learned friend was forced to resort to saying that, well, the problem is the judge didn't spell this out. And it's at that point I say, well, that's just not a legitimate submission in the light of Biogen and Phage. The judgment is not an exam paper that the judge is being tested on. Has he spelt out every conceivable reason? It's obvious that what he's saying is, I just don't know whether or not that really is lying. But even if it is, I don't think that evidence of lying 10 years ago means that I can't find that Mr. Brown was acting honestly in this trial. So moving on to my learned friend's fourth ground, which is...
Sorry, just before you leave that.
Yes, I'm sorry.
You said you weren't going to say anything more about the 18th July 2005 minute in relation to New Court.
Yes.
But I'm not sure I've got your submission on why that document is not dishonest, if that is your submission.
That is my submission, my lord.
No, you've got it at page 52 of the supplementary bundle.
Yes, I'll certainly call that.
And if I got it right, that the judge's finding was that there was in fact tabled at this meeting the DTZ report from 2002.
Yes, my lord, absolutely.
So that's the context in which we've got to look at what was said. Paragraph 5 was or wasn't, is recorded of paragraph 5 is was or wasn't something which is an honest version. I think what's said against you is it's clear from paragraph 5 that it's purporting to record a contemporaneous or roughly contemporaneous DTZ report giving an up-to-date value in relation to the property.
Yes, ma'am. That's what I understand is said against me as well. Picture the scene. Mr. Brown is at the board meeting. a 2002 valuation showing 65 million is presented. Mr. Brown has been told by Mr. Sirra that 65 million is right, and moreover, that comes from DTZ. We know that the planned confirmatory valuation was coming from DTZ.
Well, we
That is what
we
the
know
judge-
the correspondence later that that's what Buckingham said. Do we know that Mr. Brown knew that at the time? Back in July.
That is what the judge found, that the confirmatory valuation was to come from DTZ.
Yes.
I don't think there is a specific finding by the judge that Mr. Brown knew that at the time. But there's no reason, if one
And
joins the dots, there's absolutely no reason to doubt that.
well, I'm not sure about that. Because when we look at the end of paragraph 131, and we had pausing at 100.3. That's where we get the judge's reference to
Yes.
Buckingham saying that that's where it had come from. Look at the end of 131. Where the judge says the reality is that Mr. Brown considered that a value of 65 million was justified based on his team's discussions with Buckingham, and then the important words, and that the question of obtaining independent supporting evidence was left until later. Whereas if you're right, we should be reading that as the question of obtaining the confirmatory record of previously given supporting evidence was left until later.
Yes, my lord, and I would say that in the context of paragraph 100.3,
It's a slightly odd way of putting it at paragraph 131, isn't it? If that's really what was meant.
I would suggest that not in the context that the only confirmatory valuation that is talked about at paragraph 100.3, and that is from DTZ. What the papers show is that there was, where's the valuation, who is it from? The court will recall that there's a question, not from Mr. Brown, I believe from Ms. Akel, saying who gave the valuation, and Mr. Sirra replies DTZ, and then it's left that Mr. Sirra will chase. So they're talking about a previous valuation that has been given, or valuation that had advice that has been given by TTZ. So in that context, where it is DTZ who have, in my submission, confirmed what was contained in the 2002 valuation, it stands to reason that when there's a DTZ valuation tabled at the meeting, that Mr. Brown has been reassured of the figure, and that whoever it is at DTZ will be confirming that. And that's what the judge found was going to happen.
Yeah, I just think if the judge had intended to find that at the date of the meeting, Mr. Brown knew that the figure of 65 million he'd been given was a figure that Buckingham had got from RTZ, and that it was just a question of RTZ producing a formal document to record the advice that RTZ had already given earlier. And that's what would have been said at 131, rather than talking about obtaining independent supporting evidence later.
Well,
but there we are.
Yes, my lord. Your lordship has my submission. My answer to that is, in a way, yes, it would have been better to spell it out, but in the context of paragraph 100, I would suggest that it's a perfectly reasonable interpretation of the judge's judgment that he did think that Mr. Brown had it in mind. And Moreover, the honesty or otherwise of the minute and how that interrelates with Mr. Brown's conduct is obviously an iterative process. So if one believes that a witness who you've seen as a judge is basically an honest person and has been acting honestly, then the judge is more likely to have thought that the minute itself was honest. Alternatively, he might have thought that the minute was imperfect and sloppily signed. But it's not obvious dishonesty in a case where there is a TTZ valuation that's tabled and the figure of 65 million is not in dispute. It's not so strong that it undermines the judge's finding in relation to the market value, even if my learned friend were right.
Just remind me, do we know that this document, the minute, was going to be shown to the revenue?
I'm very sorry, my lord, I can't answer that. I don't know whether. Subject to the court, I'll move on to the fourth ground. Now this is what I might call the pleading point stroke the judge's job. I have dealt in passing with the broader point on this about the use by the judge of evidence from earlier proceedings and the use by the judge of an interpretation of the cross-examination that he heard. I would suggest in and of itself there's absolutely nothing that can be complained about there. So what this submission comes down to is really a very technical pleading point and a wrong pleading point for reasons I hope to show the court.
I mean, it might be said it's not really a technical pleading point. It's thrust of your case point. Why did they know they had to answer a different case?
I'm dealing with both parts. What I will be submitting is that the appellants are wrong on the technical point. They're even more wrong on the thrust of our case point.
Yeah.
If we could start by looking, please, at page 208 of the core bundle. And this is our defence. And the relevant paragraph is paragraph 14, which starts at the bottom there. Perhaps just getting the context for this. We started our defence with what one called an overview or a positive case. It's called introduction, 205. It's, as is often done these days, it's the defendants putting forward their positive case so that they don't sound excessively defensive by going straight in with denying everything. Paragraph 14, Mr. Brown is not liable, as alleged, for at all. As regards Newey, Mr. Brown was aware of the need to obtain an updated valuation of the property before Carey Street sold it to NCPL. Now, I'm going to pause right at the start and say what is not said is it is admitted that Mr. Brown acted dishonestly unless he obtained an independent formal valuation of the property before Carey Street sold it to NCPL. It doesn't come anywhere near saying that. And that is what my learned friend needs to succeed on this submission. It's a statement about what Mr. Brown was aware of. It doesn't say formal, it doesn't say independent. And that's important because we come on to the role of DTZ. But if this is being taken as a technical pleading point against me, that we're saying that the valuation had to be obtained for Mr. Brown, to be honest, that the valuation had to be independent for Mr. Brown, to be honest, and the valuation had to be formal for Mr. Brown, to be honest, you would expect a completely different paragraph than this one. This is obviously a statement about what Mr. Brown understood as part of the defendant's positive case. We go on to say that a valuation was in fact obtained from DTZ. So obviously they are independent. We rely on a letter, so that's not a formal valuation in and of itself. So we're obviously not saying it's formal, but we're not saying there that honesty requires the valuation to be independent. We're saying that what Mr. Brown did was get a valuation from DTZ. Now, I conceded at trial, both in opening and closing, that the judge could take the failure of this case into account in assessing Mr. Brown's credibility. And I suggest that that concession is obviously right. Mr. Brown is saying that this is what he did. Obviously, the extent in fact that it damages Mr. Brown's credibility is influenced enormously by the overall circumstances and the delay. And what the judge found about the natural tendency of humans to want themselves to look better. They really are. And then at C, we infer and aver that that valuation was considered and relied on by the board. So we don't actually say that Mr. Brown remembers considering and relying on, but we say it's appropriate to infer that. That obviously softens any inference on credibility that might be drawn against us. With Ludgate House, again, there's an awareness of a need to obtain an updated valuation. And then there's a double inference here at B. Although we hadn't located a valuation, we say it's appropriate to infer, and it's inferred and averred, that one was obtained, and that it showed 78 million. Now, just pausing there on that point, subject to a quibble about what precisely one means by valuation, that is basically what the judge found on Ludgate House. Valuation advice was given by Buckingham and passed on to Mr. Brown through Mr. Pollard.
Well, your submission, I think, is that you succeeded in establishing what's averred in the first sentence of subparagraph B. That an updated valuation was in fact obtained by DTZ and passed to Mr. Brown via Buckingham, and he knew it had come from DTZ. It's just not in documentary form.
Yes, my lord. Sorry, that's what I meant. Yes, sorry. That's what I was trying to say just now. If I said something different, I apologise. Yes, exactly.
If I hadn't understood it.
But yes, with respect, I agree entirely. So Ludgate House just falls away. As to the role that paragraph 14 then plays, we finish our positive case at paragraph 17. We then answer the particulars of claim. And the court saw yesterday, I don't think I need to go there again, a particular claim in which it is said that an independent formal valuation was required. And we respond from paragraphs 27 to 29 to the case that's been put against us in relation to transfers at an undervalue generally. 27, we say, as regards Mr. Brown, subparagraph 16(1) is denied. Mr. Brown authorised the relevant transfers because, having exercised independent judgment, he considered it in good faith to be in the interest of the property holding company to do so. Further or alternatively, Mr. Brown believed the consideration payable by the SPVs for Newcourt and Ludgate has to reflect the value of those properties. Paragraph 14 above is repeated. Now, it is true that we do not use the words without prejudice to the generality of the foregoing. Paragraph 14 above is repeated. Had we done so, any semblance of credibility in my learned friend's pleading point would be completely shattered. So what my learned friend is effectively doing is saying, because the defendant didn't say, without prejudice to the generality of the foregoing, we are entitled as claimants to assume that the defendants have admitted our case, that there had to be a valuation, that it had to be formal, that it had to be independent, and that if such a valuation was not obtained, Mr. Brown was dishonest. Now, that, in my submission, would be an extraordinary reading of paragraph 27(2). The plea is that Mr. Brown believed the consideration payable by the SPVs for Newcourt and Ludgate House to reflect the value of those properties. That's the plea. That's the first basis on which dishonesty is denied. And then we say paragraph 14 above is repeated. So we give our version of events. There's no admission. Just on the admission point, out of interest, below my submission was that short of an admission, Poppy M applied. And that was, we'll come to the judge's judgment in due course, but that was what underlay what the judgment found about this. The dispute below was whether or not there was an admission. But the Poppy M is correctly relied on by the judge, in my respectful submission, precisely because there's not an admission. And if there's not an admission, then it still is for the claimants to prove their case on dishonesty. Short of an admission, it must be for the claimants to prove their case. We carry on, paragraph 28. Subparagraph A is denied. Mr. Brown did not consider whether it was or might be in the interests of property holding company receive less than the market value of the relevant property, because he believed that the properties were being transferred at their market value. Now, there's no narrowing there of the case to being the paragraph 14 case. Just a statement, he believed that the properties were being transferred at their market value. And then at C, over the page, where the independent formal valuation formulation is specifically has been put against us, we respond, the phrase independent formal valuation is embarrassingly vague and is not understood. In any event, it is admitted in a verdict. Mr. Brown knew that the purchase price for each property should be the market value. So we are quibbling or cavilling at the idea that what is required is an independent formal valuation. No reasonable claimant reading this defence can genuinely think that we're accepting that it is dishonest if you don't have an independent formal valuation. Just a couple more points on the defence. Subparagraph 6, talking about the suspicion that the value might be too low. Subparagraph 2A is denied as regards Mr. Brown. He held no such suspicion.
Sorry, I wasn't keeping up with you.
Sorry, subparagraph 6
Oh,
in,
I see,
in the green
yes.
there. Further, a contemporaneous valuation for New Court was in fact obtained. So there, we do come closer to the, without prejudice to the generality of the foregoing, because it's a further submission where we rely on the DTZ valuation. Similarly, at paragraph 7, subparagraph 2B is denied as regards Mr. Brown. He had no suspicion. Further, it's appropriate to infer that a contemporaneous valuation was obtained. Paragraph 14.2 is repeated. So I'd suggest that any fair reading of this document, no claimant could have thought that we were restricting our case. Definitely not restricting our case on what honesty requires, on what is honest. That's the key. The other point related to that is, for an admission, you need common ground. Now, the factual case that was put forward by the defendants was not accepted by the claimants. They said that's not right. So there's no, not only is there not an admission in relation to what honesty requires, there's no admission as to what actually happened by claimants of what we say. So it is in dispute what actually happened in relation to the DTZ letter. Now, the rest of my submissions on this address my Lord Justice Newey's formulation of the non-technical. So we say we're right technically, and that should be an end to it. But even if we're wrong, or if there is some doubt and the court feels, well, it's a bit unfair, the circumstances of how this issue developed show that that's wrong in my submission. If we could perhaps look briefly at Clement Siddle in relation to this. It's at tab 19 of the authorities bundle. I don't think we need to get into the facts in any great detail. It's a decision of the Court of Appeal for Justices Moylan, Stewart, Smith and Lewis, 7th of November 2023, very recent. If I can summarise the case in general terms, the claimant's case, this was a personal injury case on behalf of an unborn child who was sadly born with very severe disabilities because of an accident that his pregnant mother suffered while holidaying at a Lake District hotel. The claimant's case, the unborn, previously unborn child, was that his mother had fallen at a particular spot close to a jacuzzi where there was some unguarded decking. What the Court of Appeal found was that the location and the fact of the fall was not challenged by the defendants. They merely put the claimants to proof. After the evidence, the judge in effect allowed a changed case late in the trial to the effect that the accident had happened elsewhere within the jacuzzi area, with consequences for the evidence that the claimant had given. Now, the Court of Appeal found that this was wrong on the facts, and that in any event, the approach was wrong, given what it was reasonable to understand by the claimant of the defendant's case. And we see that from paragraph 77, page 784 of the bundle. Paragraph 7, it's perhaps convenient to start with the general principles about the formulation of issues in adversarial litigation, which are not new and can be summarised by reference to established authority. It's fundamental to our adversarial system of justice that the parties should clearly identify the issues that arise in the litigation so that each has the opportunity of responding to the points raised by the other. Statements of case play a critical role in identifying the issues to be determined. That is not to say that a trial judge may not permit a departure from a pleaded case where it is just to do so, although in such a case it is good practice to amend the pleading, even at trial. The function of the judge is to adjudicate upon the issues identified by the parties alone. Adherence to the issues that have been identified by the parties, in particular by the pleadings, prevents the trial from becoming a disorderly free-for-all. The task of the courts is to do justice between the parties in relation to the way in which they have framed and prosecuted their respective cases, rather than to carry out some wider inquisitorial function as a searcher after truth. Then carrying on paragraph 78, case management in accordance with the overriding objective should always be directed to ensuring that the issues for the court to decide are identified and there should be clarity both about what is agreed and what is not agreed between the parties. Such an approach is essential to dealing with any case proportionally, expeditiously and fairly. To that end, issues and matters of agreement or disagreement may be identified and refined by pleadings and thereafter by case summaries, list of issues, and even skeleton arguments. So the court has in mind that in appropriate cases, I would suggest it's only when there are tweaks, but in appropriate cases, the case that's being run can be tweaked even after the pleadings, as long as that's made clear at a time that it's appropriate and that it's fair for the other side to be expected to respond to. Carrying on, as in the present case, and then over the page, they will typically be negotiated and drawn up after closing pleadings and the exchange of witness evidence by their expert at a time when the parties can and should liaise to ensure the future conduct of the case is expeditious and fair. It's typical for case summaries to have sections specifically devoted to identifying what remains in issue, i.e. a list of issues. In addition, it's entirely routine and good practice in an appropriate case for lists of issues to be prepared. May provide further refinement, what's in issue. Finally, the parties have another opportunity to identify matters in their opening skeletons for trial. The end result of these procedural steps should be that an objective observer can identify what are the issues the judge is to decide in order to resolve the case. And then at 79, the CPR makes additional provision for the making and withdrawing of admissions. Paragraph 80, just to show how this is applied by the Court of Appeal, the present case, the pleadings taken alone did not remove the location from which Dr. Clements fell from the issues to be decided. I'd like the court to consider the rest of paragraph 80 and 81.
Do we leave it there?
Yes, please, my lord. So the Court of Appeal is not considering that there's some arid technical approach taken. It's about fairness. It's about taking a sensible approach to what is seen by the parties to be an issue. So how did the issue develop here? Well, as the court knows, our primary submission is it was always obvious what our case was on the pleadings. But as my learned friend sought to anticipate yesterday, there were a series of lists of issues exchanged. There was never a final agreed list of issues. But what I want to show by going to list of issues is that the claimants fully understood what the defendants were saying until they chose to take a technical point just before trial. So if one's looking at the fairness of what the claimants really understood the defendants to be saying, there's only one answer. Now, the list of issues are in the respondents bundle behind, I believe, tab 5. Hopefully I can take this quickly. And my learned friend misanticipated the submission because he thought we were going to be relying on what we said. We're not really relying so much on what we said as on what they said. If we look at the first list of issues from January 2022 at the CMC, produced at the CMC. This is produced in the top of each of these versions in red in the top left-hand corner. We have added now a little guide to who produced these and when. This was produced by the claimants, this first document. Issue 4, was the purchase price less than the market price of the property at the date of its transfer? If so, by how much? Did Mr. Brown and or Equity Trust honestly believe that the purchase price was equal to the market value of the property being transferred? Etc. No suggestion whatsoever that our defence is narrowed by reference to an acceptance that that could only be the case if there was an independent formal valuation. The second document, just to see what we did say in response, although we disagreed with the format of the list of issues, paragraph 9 of the second document, which was produced some 4 days later, our proposed issue was, did Mr. Brown and or Ms. Denner believe consideration payable in respect to the properties to reflect their market value?
Sorry, where are we?
Page 15,
yes, I'm sorry, I've been avoiding pagination because I don't think I have the same.
It's the bottom of our page 15.
Thank you, my lord. I apologise for not having quite the same. Okay, so I'll add 8 to what I have. Did Mr. Brown believe?
And sorry, that was paragraph 9.
That was paragraph 9. The third document, which I believe will be your page 17, May 2022, produced by the claimants, again, this is their version, over at page 18, report and Ludgate as was the purchase price less than the market value of the property at the date of its transfer? If so, by how much? Did
Sorry, I'm not keeping
I
up.
have lost you on the page numbers. We've got a document that starts at our page 18.
oh, sorry, so I'm now on page 19,
Which paragraph?
paragraph 8.
Was the transfer at an unlawful distribution?
The document we're now looking at says not agreed claimant's list of issues. Is that the right one?
What may I ask the court what you have at page 10?
Page 10 is part of a document dated 6th of May 2022, draft list of issues, claimants.
Ah, yes. In which case, I think when I answered my Lord Justice Popplewell earlier to say that my pagination was different, obviously I was mistaken, and that was the next draft list of issues. But the point, it is page 10 that I'm looking at now, and this is the claimant's list of issues of May 2022.
And what was the occasion for this one being produced?
My lord, before a disclosure hearing for the disclosure review document.
And again, so paragraph 8 was the purchase price less than the market value. Paragraph 9 was said by how much did Mr. Brown and or equity trust know? That qualifies paragraphs which follow. As the interests of the company, the purchase price ought to be the market value as ascertained by a contemporaneous independent formal valuation as at the date of the transfer. That the purchase price was not being set by reference to such valuation, or suspect that the purchase price to be paid by the SPV was materially less than the market value. That they did not have reasonable grounds for believing that the purchase price was the value at market value. That the purchase price was not being set in the interests of the property holding company, but dishonestly. So even then, there's no restriction by the claimants on what the defendant's case on honesty is. Now that comes in.
Sorry, let me just read it through a moment.
Sorry.
Well, it's a bit clear, isn't it? Because at 9B2, there's the reference to did he know, or did equity trust know, that the purchase price ought to be the market value as ascertained by a contemporaneous independent formal valuation.
Yes,
Mike.
fine. Yes, my lady, but this is page 11. Little Roman 5, it's also in issue whether or not Mr. Brown and Ms. Leonard had reasonable grounds for believing that the purchase price was the market value. So with respect, my lady, Lady Justice Asplin is absolutely right that it's not in dispute that there was an issue about whether there was a DTZ valuation or what was required, but it's whether or not it was the only basis on which Mr. Brown and Ms. Leonard could be acting honestly. And what changes is an attempt shortly before trial in January 2023, when we see the document behind tab 5 at page 18. And then the claimants seek to introduce in the first issue, did Mr. Brown obtain a contemporaneous valuation, and then B, as a result, genuinely believe that the market value was 65 million. But even then, they go on at sub-issue 2 to say, if not, did he know or have blind eye knowledge that the market value was materially more than 65 million? And similarly in relation to Ludgate House at issue 6.2. And thereafter there is what might be described as an unedifying spat between us about whether our case was restricted. So on
So,
what
sorry, are you leaving these documents?
I am,
So can we just see what you said to which
yes, of
the
course.
claimants took exception?
What we said is probably best seen at the final version of our list of issues is page 33. Sorry, yes, my lady, it starts at 32, and the part I wish to refer to is at 33. Paragraph 2. Well, paragraph 1 is what's the market value. Paragraph 2, did Mr. Brown and Ms. Leonard honestly believe the consideration payable by NCPL for New Court to reflect the property's market value? And then 3, are the defendants, as the claimants contend, limited to asserting that Mr. Brown and Ms. Leonard held such honest belief by reason of the DT said letter?
So you put this forward on the 24th of February.
Literally just before trial.
Right, it says 2024, that must be 2023, I assume. And the claimants object to that.
The claimants objected to that, but there's no further draft. So at that point,
And you make clear that you're seeking to stand by your draft.
yes, and stand by our interpretation of our drafts. There's no doubt that they know what we're saying our case is, and that is why I say that this is the most technical of technical pleading points. Even if it's right, as you know, I say it's wrong, but even if it's right, they know exactly what we're saying. And so that's why I addressed the court in opening, because this had been identified as an issue. And it is that fact of addressing the court in opening that is then referred to by the judge. I won't, certainly don't want to take the court to my submissions, but for reference, it's from
So this is in the transcript bundle you've given us.
yes, absolutely. From page 62 of day 1 of the transcript. And to a significant degree, what I said then was what I said now.
So by the time, I mean, there was only one witness of fact.
Yes,
So by the time the only witness of fact is cross-examined, the claimants were clearly on notice of what your case was.
yes, exactly. And closings were on day 1. Sorry, openings were on day 1. That would have been a short trial. Cross-examination started on day 2.
And the reason that that wasn't agreed to be an issue in the arena was because the claimants were saying that takes you outside your pleading.
Yes.
And just to be clear, at that stage, at the opening stage, the judge doesn't express a view on whether you're within your pleading or not in your pleading.
I think that's fair, my lord. The judge listens to what I'm saying. He doesn't make a definitive ruling. I understood him to be receptive, but there was no definitive ruling.
Yeah.
And he certainly didn't say, if we're looking at fairness here, given that this is the way in which the defendants very, very clearly wished to prosecute their defence, the judge didn't say, oh, well, I'm sorry, I think you need to amend if you're going to say that. That was, I mean, the reason for airing it was to make the position clear, precisely because we thought an amendment wasn't necessary, but if we had been pushed towards one, obviously we could have applied for one. And it's suggested then that Mr. Brown admitted this in his evidence. Well, I can only ask this court to look at potentially sort of 16 pages of Mr. Brown's cross-examination or more, and I don't have time to do that because the truth is his evidence is unsatisfactory. He goes back and forth, but he clearly considers the possibility that Buckingham provided the advice at times. And my learned friend has shown you bits where Mr. Brown then says, oh, well, I think I would have got the formal valuation. And then he goes back and says, yeah, and that could have been from Buckingham. And Mr. Parker clearly understood that that was what Mr. Brown was saying, because if we can just turn up one page, and this is in the Appellants bundle. Page 38. Is where the passage starts. Record has been taken to page 38, and by my highlighting, the court was shown page 3 and some of page 4. But then at the bottom of page 4 from line 14, my learned friend asks, and you would only agree to transfer once you had seen the transfer price accorded with that independent expert valuation. That's your evidence, isn't it? That would follow a process, and we would have a valuation, and that Francis and I would make a decision for transfer on that basis. And the valuation would be from an independent expert, such as DC said, not necessarily. So there wasn't any procedure. Sometimes it would be an independent expert valuation, sometimes it wouldn't. And then Mr. Brown says, no, it would be a valuation. If we go down to the next answer, it would be a valuation that we would request. That may be DTZ, or it may be a form of market valuation at the time. What, from anybody? No, the connected parties to the transaction. So in this case, we had Buckingham Securities, who were our property advisor involved, and sometimes we went to Buckingham because they were property experts in the London market to get a valuation. And then the back and forth goes on for many pages. And if we can sum up Mr. Parker's understanding of what Mr. Brown was saying at the time, at page 16, which is page 41 of the bundle.
So sorry, which page?
Sorry, page 16 of the internal transcript, which is page 41 of the bundle. The second answer, so yes, valuation and also the ongoing discussions we had with Buckingham, who are very close to the market. Okay, so you are saying that sometimes you wouldn't actually get a valuation from Buckingham, you would simply rely on discussions with Buckingham. There was ongoing discussions with Buckingham at this time, so we generally knew the value of each of the properties in the portfolio, but it doesn't depend on transaction, but it would depend on the transaction or the nature of the reason for the valuation. Now, your lordships and your ladyship have already been shown what the judge concluded in relation to that. So, in the interest of time, I won't go back to that. It's at paragraphs 59 to 66 of the judgment. And by way of summary, all I say is that the issue is very clearly before the court. The judge was quite right to find that it was before the court. The only unfairness would be if the defendants were artificially restricted from running the case that everyone knew was their case. There is a point on credibility, and I made that concession. But that was taken into account by the judge in his judgment. Moving on to section F of my learned friend's skeleton, and it's grounds 15 to 18, which is the attack on the other factual findings, not the transfers. Now, in relation to these grounds of appeal, my overarching submission is that these do not in any way suggest a basis for saying that the judge is plainly wrong. Nothing is identified that legitimately calls into question the judge's fact finding. There is no obvious mistake. And many of these grounds appear to be dependent upon dishonesty in relation to market value having already been established in the claimant's favour. So if we look first at the dividend, as I understand it, there are two limbs to the complaint. The first is reliant on the issue of whether or not Mr. Brown thought the transfer was at a market value. I've already addressed that. There seems to be a secondary attack that if the transfer was at an undervalue, the judge shouldn't have found in the alternative that any breach in relation to the dividend was honest. Now, the judge did find that, but very clearly in the alternative. So the judge's primary finding is there's no undervalue, there's no awareness of an undervalue, so the case on the dividend fails in limine. And the additional reason that is complained about in that alternative scenario is that the judge places reliance on the share subscription agreement and says that there was no prejudice to any potential creditor. Now, in the course of his submissions and in the appellant's skeleton argument, the appellants say that the defendants made a concession about the effect of a finding of dishonesty in relation to market value. We didn't. The reference that the court was given was in the supplementary bundle at page 22. These are extracts from the defendant's written closing submissions that the appellants wished to rely on behind tab 2, page 22. And paragraph 180.2 is relied on by my learned friend. What we say there is it's hard to see how Mr. Brown and Ms. Leonard could have known that the interim accounts were flawed in the manner alleged or being dishonestly reckless as to whether they were, unless they knew that the new court had been transferred at a material undervalue. On any realistic view, the success of the claim in respect to the transfer of new court is therefore necessary for the dividend claim even to get off the ground. Now, it is simply not a fair reading of that paragraph to suggest that there is a concession that if there is a finding of a transfer at an undervalue, the dividend claim succeeds. The extract from the closing submissions in material respect ends there. we put in the respondents bundle our full closing submissions, and it might just be worth looking at what we went on to say, in particular from page 49. Sorry, it's page, yes, it's 49 internally, which is page 66 of the bundle, sorry. So this carries on from the extract that was put into the supplementary bundle. And there's a discussion between paragraphs 185 to 189, but at paragraph 190, to the extent that there was any doubt at all as to what we were saying, such doubt is removed when we say a further fatal defect with the claimant's case in relation to the dividend is that Mr. Brown perceived absolutely no risk of prejudice to creditors, even if there turned out to be a tax liability for which CSIL had not made provision. Mr. Brown's evidence that we did retain with the company the amount of money that was payable for tax, we did take into account when making the decision that we had coverage for any tax liability through the deed with Irons. So it certainly can't be resolved by way of a concession, or a concession that the judge sort of wrongly ignored. That simply goes nowhere as a submission. I think this was adequately addressed yesterday, but what my learned friend seemed to be saying was that if Mr. Brown did misrepresent the position to the revenue in relation to the value, then he cannot have honestly thought that there would have been protection in the form of the share subscription agreement. Now, in my submission, that just doesn't follow, because what is being said in that scenario is that Mr. Brown was putting forward not a figure that was completely made up, that he knew the revenue weren't going to accept, but in that scenario, this is not my case, but in that scenario, that he's putting forward a figure from a range, aware that there are other possibilities. So in that scenario, Mr. Brown is simply aware of a risk of challenge, just as he is in relation to any other potential tax liability. So it actually makes no difference. But we don't even get there if there's no dishonesty in relation to the market value. I'm going to take the management charges and interest together. And the key point again is that this court is simply being asked to replace the judge's view with its own view of some of the documents. That was the effect of my learned friend's submissions. Look at these documents. They show that the judge's fact-finding is wrong. That is classic cherry picking or island hopping. Even so, since it's been addressed, I will address the substance to the extent that I'm able without going back through the entirety of the closing submissions. Obviously, our closing submissions are in the bundle if required. On the management charges, the appellants, we say, fail to appreciate the overall assessment of Mr. Brown's approach done by the judge. That assessment was that Mr. Brown was careless and took shortcuts. The appellants instead ignore that and assume that Mr. Brown noticed all the inconsistencies that my learned friend relied on yesterday. So inconsistency leads to dishonesty, is my summary of my learned friend's submission. Inconsistency in the underlying documents, but that's not right. Inconsistency might lead to breach of duty. Doesn't lead to dishonesty. And the judge very clearly had that distinction in mind. The judge found that Mr. Brown could be criticised for the way in which these issues were handled. But he said he didn't make him dishonest because he relied on Buckingham, who he considered was in the best position to assess these things. Interest is very similar to management charges. The judge found that Mr. Brown should have investigated, but instead relied on Mr. Sirra's advice. It wasn't so obvious that where, in accordance with normal commercial principles, interest would be paid on a loan, that the charging of interest was inappropriate. One's got to bear in mind, as the judge in my submission did, that when these charges were agreed, Mr. Brown had just started as a director of Carey Street. One finds that at paragraphs 22 and 23 of the judgment. We don't need to go there. But in reciting the general factual background, the judge makes a point of observing that the charges that were agreed just after Mr. Brown came into position. And it's in this context, my learned friend took this court to various things that have been written by others in Mr. Brown's team and just said, there you go, Mr. Brown knew this, there you go, Mr. Brown knew that. Well, precisely what impression Mr. Brown formed was a matter for the trial judge, having heard Mr. Brown give evidence. And the trial judge found that Mr. Brown acted honestly. That is not plainly wrong. Finally, on the specifics, the 766,000 retention of a loan from the subsidiary to the parent in relation to Ludgate House. The complaint here also, we say, seems fundamentally to be dependent on the underlying issue of dishonesty in relation to the transfer value. If Mr. Brown was otherwise acting honestly, the judge was obviously right not to see that there's a separate problem with this. But even if Mr. Brown knew there was an undervalue, we say it was still not unreasonable for Mr. Brown to accept that part of the purchase price would be paid by way of a loan, would be deferred in effect, let alone dishonest. That loan was a valuable claim against the parent company. And that's what the judge found from paragraphs 259 to paragraphs 265. I don't ask the court together now, but it's hard to see that there's any basis to disagree with this analysis, let alone that the judge is plainly wrong. if I may, I'll turn to the issue of valuation evidence. This is ground 19 of the grounds of appeal. We say that the appellant's case on this is a very strange mix of unevidenced assertion and a highly problematic invitation to this court to conduct a very partial review of the very extensive expert reports and cross-examination and submissions. On that basis, it should be rejected in limine. I will, of course, deal with the substance in any event. On this, we need to start by looking at what the judge found. The judge's findings on valuation are from paragraph 324, which is at page 158 of the full bundle. And if I can summarise what the judge finds between paragraphs 325 and 330, it is that neither expert was wholly satisfactory. Both had their faults, but he was going to do his best by reference to the collective evidence that they provided. There's no specific issue taken with that, and I suggest it's very obvious an appropriate approach. Paragraph 331, the judge identifies that the main differences are the choice of comparable properties. Final sentence there, it's apparent that the main differences between the experts are their choice of comparable properties against which the yield should be tested and the extent to which possible future development potential should play a part in determining the yield. Excuse me. Bearing in mind that at this point, the judge had heard a day and a half of cross-examination of the experts. There's 250 pages of transcript cross-examination. I did think about taking your lordships and your ladyship through that, but decided it might not be popular. There's 250 pages of expert reports and appendices. There's 40 pages or more of written submissions. Now, only half of that related to New Court. But that's still a very substantial body of material that the judge is distilling into a quite pithy summary. Therefore, going to remind this court of Phage and what was said about the appropriateness of pithy summaries. They're not inappropriate. And that's what the judge has done here. 333. In this case, I prefer Mr. Whitfield's valuation. This is for the following reasons. Mr. Whitfield explains how he reaches his yield of 6.25%. Both parties accept that a starting point of 5.5% is appropriate for the area mid-town properties. Mr. Whitfield added 1%, given the poor state of the property, a further 0.25 in respect to the relatively short unexpired term, and then reduced the yield by 0.5% to take account of the strength of the covenant. I'm sure it's obvious to this court, but certainly wasn't obvious to me when I started reading this. A reduction in yield equates to an increase in the value of the property. And so he came, Mr. Manley, on the other hand, performs no such calculation, but simply expresses the view that the yield of 5.5%, i.e. the appropriate average yield in the area, is appropriate as this reflects the inherent potential of the property. So that, against that background, the judge's first finding is that the most relevant comparables appear to support Mr. Whitfield's conclusions. Time and time again, the only response Mr. Manley had as to why a company was inappropriate was the development potential attributable to New Court. Now, that is condensed, but that is the judge's expressed view after hearing literally hours of questions about comparable properties on New Court, if you combine both sides' cross-examination. He doesn't say at line 25 on page 32 of the transcript, Mr. Manley looked deeply unconvincing when he said X, and Mr. Whitfield looked rather more convincing. The judge doesn't have to do that, but it's implicit in this. The next paragraph, Mr. Manley cross-checked his conclusion by producing a site value for New Court based on development proposals mentioned by Colliers in their valuation report prepared in July-August 2005 for Credit Suisse in relation to Project Ocean. Mr. Manley concluded that the site value was 92 million. However, in cross-examination, it became clear that the site value is extremely sensitive to changes in the assumptions made, such as the likely rent, the number of square feet which can be let, and the building costs. And this court will appreciate why that might be the case. You're looking at a present value of a future income stream with lots of different variables, including what's the square footage that you're modelling, what's the rent that you're modelling, what are the costs that you're modelling. And I took Mr. Manley through those in great detail, pages and pages of transcript on that. And again, what the judge is saying is that having heard that, I found that the modelling of Mr. Manley was very sensitive to changes. And just as an aside, one can see that somehow Mr. Manley has got to get from 92 million to 72 million. And we'll come to the detail. But part of the problem I would suggest that the judge had is that no proper explanation was given for that, of why you come down from 92 to 72 rather than to 65. If you're coming down to 72, why aren't you coming down to 65? And my learned friend says, the judge's complaint about the reduction in yield isn't fair because the experts weren't asked to separate out the approach to the yield. But what I would suggest the judge is encapsulating there is a difficulty in marrying up the model with the value. And then in addition, Mr. Manley appears to have misunderstood in his report the nature of the development being referred to by Colliers. It's clear from Colliers' report this is a single mixed-use 25-storey development totaling 420,000 square feet. Mr. Manley appears to have concluded there were two possible developments, one mixed-use and one 420,000 square feet. He's assessed the site value on 420,000 square feet of office space. It's true that the body of the Colliers report refers both to the construction of an entirely new building as well as a refurbishment extension. However, the more detailed appendix clearly shows a single proposal for a mixed use of property of 420,000 square feet. Now, there's a complaint in relation to this that Mr. Manley wasn't cross-examined. Mr. Manley was cross-examined at great length about the possibility that a different floor space might be appropriate. In the course of that, I'm saying, how do you get to that figure? Mr. Manley said, oh, I looked at the architect's drawings. Now, yesterday my learned friend said, Mr. Manley can't be criticised for not having referred to those in his report. And I agree, because they were only made available later. But that was news to the cross-examiner. So there wasn't the ability in court to say, well, let's have a look at those models. Mr. Whitfield, when he was giving evidence, said, I've had a look at those models, and basically said what formed the basis of the judge's conclusions, but they're not particularly reliable. But the sensitivity of the model stands regardless of 333.4. And the fundamental point that Mr. Manley couldn't have been sure that it was appropriate to model on the basis he did also stands. Since I'm in the judgment, before I move away from it, 333.5, for all these reasons, no reliance can be placed on Mr. Manley's assessment of site value. As Mr. Whitfield commented, the valuers simply do not have the information for them to make an accurate assessment. Mr. Manley further cross-checks his conclusions against his view of the value of Newport when it was purchased in May 2002 and against the eventual sale price of 60 million in May 2010. So this is obviously after the market had taken a downturn. He does this by looking at the MSCI index for Midtown and West End properties over the relevant period. Mr. Manley's starting point was that Newcourt should be valued at approximately 65 million in May 2002. However, in cross-examination, he accepted that an actual market transaction provided the best evidence of market value. Over the page, on this basis, the starting point should have been the figure of 60 million actually paid. Sorry, I inserted actually. Paid by the Irons R structure for the property in May 2002. If this is taken as a starting point, the graph produced by Mr. Manley in his report showing the change in the MSCI index would support a value much closer to 65 million in May 2005 than to his figure of just over 72 million. In other words, Mr. Manley got the starting point wrong. If you start with the right starting point, actually, this rather supports Mr. Whitfield's valuation and not Mr. Manley's. Mr. Whitfield was saying 65, a couple of 100,000. Mr. Manley was saying 72 million. It is the complaint that I believe is being made here is that if this is the correct approach, then the judge should have looked more carefully at what the MSCI index said and ended up with a figure of 66 million odd. In other words, it didn't actually come out at 65. But that's not what the judge is saying at all. The judge is simply saying, Mr. Manley used this as a cross-check, but actually the cross-check isn't as useful as he thinks it is because it comes out at a figure that's closer to Mr. Whitfield.
Could I just clarify so that another friend has the opportunity to respond at what we were intending to say?
Yes.
Was if the judge, if the court thinks the judge was entitled to reject Mr. Manley's report, were to accept, but we say if he's doing that, he still doesn't have a basis to accept Mr. Whitfield's report. So maybe then what the judge should have done, if the judge is going to rely on the MSCI index, he should have arrived at a figure by reference to that index. So what my learned friend's saying about how the judge uses the index, we accept that's how he does use it. But what we're saying, if you're going to throw away Mr. Manners' report, as the judge did, and if you should, as we say, throw away Mr. Whitfield's report for the reasons hopefully we've said, then one option would have been for the judge to use a figure derived from the MSCI index.
Yeah.
Thank you.
Yes, I'm not quite sure how on that basis this is an issue that this court can possibly get engaged in. That sounds like the continuation of an argument below. The point is, the judge is not saying that Mr. Manley was right to do that. What the judge is doing is, by way of a final aside, hoisting Mr. Manley by his own petard. He's saying, if you apply Mr. Manley's methodology, you get a figure close to Mr. Whitfield's. No reason why he should have employed that methodology. He has Mr. Whitfield's report. And then my final points on development potential relate to the second complaint that I understand the appellants to be making, which relates to this alleged lack of specific adjustment to the yield to account for development potential. Now, I would suggest that this ground of appeal is misguided or simply misunderstands the judgment. Quite apart from the fact it comes nowhere near the test of showing that the judge was plainly wrong. Again, he was in fact obviously right. The appellants appear to proceed on the basis that not every building can be developed, and that the development potential where it does exist necessarily reduces yield. These points are not quite right, and the way in which they're wrong undermines the appellant's argument. Of course, every commercial office building in London can in principle be developed at some point. The question, when considering development potential, is purely one of comparing the relative value of, on a development basis, versus the value on an undeveloped basis. When does the development value come into play, is the question. Now, that may not be desperately clear. Hopefully Mr. Whitfield's evidence makes that clearer. That's in the appellant's bundle. Page 114. From paragraph, so it's behind tab 16. Thank you, 16. This is the supplemental report of Mr. Whitfield, extracts from paragraph 42 onwards. See that what Mr. Whitfield in his supplemental report, so he's obviously seen Mr. Manning's report, says, I agree with Mr. Manning that it's likely that New Court would have been viewed as a development opportunity in due course. The reasons set out within my opinion against item 8 in the joint memorandum, I don't consider the exercise he has undertaken to derive a residual site value and in turn an internal rate of return is representative of the exercise that would be undertaken by the market at the New Court valuation date. New Court did not have the benefit of planning permission, nor was there any settled scheme for its redevelopment, which in any event was more than 6 years into the future at the New Court valuation date.
That was because it wouldn't have vacant possession, was it, until that was the 6
Yes,
years?
yes, exactly. There was a government, a lease to the government. Paragraph 44. A purchaser considering the market value of New Court will be interested in ascertaining whether the site value, most likely assessed on a range of schemes, starting with replacement of the massing of the existing building, that is the same height and overall gross area, through to an increase in floor space, to a combination of either height or building efficiency. It's likely to be similar to, higher or lower than the market value of the property assessed on an investment basis. So that's the comparison that I was inexpertly trying to explain a moment ago. On the assumption that the values were similar, a prospective purchaser would take a degree of comfort that the residual site value of New Court would underpin its investment value, which over time was likely to depreciate as the unexpired term shortened.
Sorry, can I just read that sentence again? Yes.
So if the investment value, the basic value based on yields that both experts are taking is carrying on roughly flat and then starts diminishing at the end, you've got in the background the development potential, which starts off underneath, and then at some point it will increase and overtake the investment. value. So it's an exercise of expert judgment, whether you have enough information to know that the development potential is the right approach here. And effectively what Mr. Whitfield said, in my expert opinion, there's not enough certainty. You can't be sure. Mr. Manley he's being too speculative. And
I
that's
mean, jumping into a tiny bit of all this, it does seem a bit odd that you increase the yield to take account of the short term in circumstances where it's going to be redeveloped.
that is by comparison with the other properties that you are considering. So obviously you start, what both experts do is start with an average yield. So implicit in that is a finding about the terms that are available on each of those other properties and what the development potential is for each of those other properties. So perhaps, my lord, it's not, I understand what your lordship is saying, but it's not perhaps quite as odd as it might seem if you just take that basic figure without considering that it is an average of all the other properties in the area. And what was unsatisfactory about Mr. Manley's approach was that having conducted these impressive calculations to produce a figure, there was very little to say how that translated into yield.
Yeah.
Because they are two different approaches, and he hadn't assimilated the approaches, quite apart from the fact that the modelling was too speculative. So there were two problems that the judge found, and with respect, either one would be enough for the judge to have preferred Mr. Whitfield's evidence to Mr. Manley's. Combined, they were easily enough, and on that basis, we say the judge was right to find that Mr. Whitfield was right and Mr. Manley was wrong.
And not indeed to choose somewhere in between.
Yes, and that decision not to choose in between is made clear at paragraph 336 in the judgment, page 162. Perhaps just refer back to 335 as well, which encapsulates broadly the point I was just making, that noteworthy that yield on the properties which form the comparables do, of course, take account of potential development value. They also take account of the average amount of revenue potentially available on the lease. And then at 336, overall, in the absence of any reliable assessment of development potential for New Court, coupled with the lack of any suggestions what specific adjustment should be made to the yield to reflect whatever development potential the property may have had, it's not, in my view, appropriate to make any adjustment to the yield proposed by Mr. Whitfield to take account of the development potential. And it's a very small point to finish off, but the overall assessment was not all one way. And in relation to Ludgate House, a figure closer to Mr. Manley's figure was found to be correct in relation to Ludgate House. So the judge was clearly thinking about and addressing his mind to all the relevant issues and reached an unassailable factual finding in my submission. Unless I can assist this court further.
That's very, very timely.
May I hand over to Mr. McCall, Fritz?
Mr. McCall, Fritz.
Sorry, may I just...
My lord, may I just have one moment?
Yes.
The lectern I'd like to use was being used to prop up some of his microphones. that setup will do for the overs before lunch, at least. My lords, my lady, I am addressing the grounds that concern equity trust alone, grounds 20 to 23. As you'll appreciate, those grounds will only require determination if this court overturns the judge's conclusions that Mr. Brown is not liable in relation to any of the impugn transactions. Grounds 20 to 22 all concern equity's vicarious liability for Mr. Brown's supposed fraud. Mr. Brown is the only equity employee alleged to have acted fraudulently. If, as the judge held, Mr. Brown is not liable, there can be no question of vicarious liability arising. Ground 23 concerns the question of whether equity was a de facto or shadow director of the claimant companies. The judge held on the facts that it was neither. He said rightly that it was conceptually possible for equity to have been a de facto or shadow director of the claimant companies other than through Mr. Brown, but a finding that equity committed dishonest breaches as a shadow or de facto director would depend on a finding that a natural person acted dishonestly, and the only natural person in the frame was Mr. Brown. On the pleaded case that the claimants were stuck with after failing their amendment application, it was Mr. Brown or no one. So again, if the judge was right that Mr. Brown was not liable for dishonestly breaching the duties he owed as a de jure director, there is no question of equity being liable as a de facto or shadow director. Even if it was a de facto or shadow director, it would have needed to have acted dishonestly through Mr. Brown because there was no other candidate through whom it could have acted dishonestly. If I might explain the proposed structure of my submissions, I will begin with ground 23 concerning equity's supposed liability as de facto or shadow director. The appellants persist in conflating the distinct concepts of de facto and shadow director. I will treat them separately as they should be treated. They are distinct concepts, although there is some limited overlap between them. Echoing the judge's approach, I will deal first with the appellant's challenge to the conclusion that equity was not a shadow director of the claimant companies. I will then deal with the challenge in relation to the de facto director question. Having dealt with ground 23, I will turn to the vicarious liability grounds 20 to 22. But before turning to ground 23, I should make some headline points relevant to all four grounds that I'm addressing. First, although the grounds are presented as raising legal questions, on a proper analysis, they are, once again, challenges to unassailable factual findings and/or evaluative judgments. The judge did not misdirect himself at all as to the applicable legal principles. He identified the principles correctly and then applied them to the facts as he found them. He applied the relevant legal principles in a way that the appellants wish he had not done, but that does not mean he committed any error of law. He did not. We clearly don't need to turn back to Lord Reed's statement in Henderson and Foxworth, in particular paragraph 67, but the circumstances in which it is appropriate to disturb a trial judge's findings of fact or evaluative judgment are extremely limited, and as my Lord Lord Justice Popplewell said yesterday, limited to circumstances in which that factual finding or evaluative judgment is plainly wrong in the requisite sense. And the requisite sense is a finding or evaluative judgment that no reasonable judge could have reached on the material before them. It is an extremely high bar. The second headline point is that in advancing grounds 20 to 23, the appellants ignore time and again the facts that, first, the burden of establishing that equity was a de facto or shadow director or is vicariously liable for Mr. Brown's alleged breaches lies squarely on them. And second, more important, The appellant's wholly unexplained delay in bringing the present claims meant that documents were lost, Mr. Brown's memory degraded, and other witnesses who could well have been able to give evidence if the appellants had not delayed so long might have been called by the defendants. Ground 23, my lords, my lady. As I'll endeavour to show you, across the board in the grounds I'm dealing with, there's a disconnect between my learned friend's submissions and his grounds. He's tied to his grounds. I'm not taking any over-technical pleading points. He can only advance an appeal on his grounds. He can't make it up as he goes along. So let's look at ground 23. Core bundle, tab 1, page 29. As you'll see, it is said that the judge erred in law by making the perverse finding that Equity was not a shadow and or de facto director of the claimant companies. Note well the and or, it really has to be or, in this case at least. It is presented as a legal challenge, but it is in substance a factual challenge. That's entirely consistent. We'll come to Smithton, the judgment of Lady Justice Arden. But she makes clear in that case, shadow director, de facto director are concepts that are well delineated in law. Shadow director as a matter of statute, de facto as a matter of well-established authority. So as long as you get the principles right as the tribunal of fact, your decision as to whether someone is a de facto director or a shadow director is really a finding of fact. So they don't point to any error of law. They can't possibly. The judge correctly identified the statutory test for shadow director and correctly identified the principles applicable to the question of whether someone's a de facto director. So you should just strike through erred in law. The challenge is that he made a perverse finding of fact that Equity wasn't either of those two types of non-de jure director. I will return to the basis for what is a pure factual challenge in due course, save that it's convenient to address subparagraph 5 at this stage. That subparagraph concerns the assertion by Equity of a legal advice privilege in relation to advice provided regarding the impugned transactions. The assertion of privilege was made by Equity long after the event, when it was on a war footing in relation to the Angelmas transaction and the Angelmas proceedings, and then in 2018 in relation to the transactions to which these proceedings relate. It was a point that Equity chose to take in correspondence. The claimant stridently rejected it. No court has ever decided that it was rightly made. It casts, in my submission, no meaningful light backwards to the time of the transactions and how things were done at the time. It was just a point that was taken after the event and never decided either way. It would therefore be quite wrong to proceed on the basis that Equity was entitled to assert privilege in the advice, which is what my learned friend Mr. Parker uses as a premise for this challenge. His clients robustly denied that throughout. But even if, and I cannot see how it could be right, but even if Equity was able to assert privilege as against the claimant companies in respect of these transactions, it would not follow, not remotely follow, that Equity was necessarily a shadow or de facto director of those companies. It's logically incoherent. If Equity was a shadow or de facto director of those companies and received advice in relation to transactions that those companies were to enter into, the last people in the world it could assert privilege against would be the companies of which it was a de facto or shadow director. It just couldn't do it. But for my learned friend's attack on the findings of fact to have any weight at all, it would need to be possible to be said that, oh, well, because Equity Trust was able to assert privilege, it follows that it was a shadow or de facto director. And it does not. If it was able to assert privilege, that would merely be a factor to weigh in the balance. As we will see, the judge did weigh in the balance explicitly the fact that Equity, rather than the claimant companies, received advice. So the challenge on subparagraph 5 pivots narrowly on the contention that the judge gave that fact to which he expressly alluded and weighed in the balance the wrong amount of weight. That is hopeless. So, my lords, my lady, looking back at subparagraph 5, under sub B, what is said to be the logical consequence of the facts posited is no such thing. It is an obvious non sequitur. The only true logical consequence of the conclusion, which has never been drawn, that Mr. Brown became aware of the relevant advice solely in his capacity as employee and director of Equity, is that he became aware of the advice solely in that capacity. It has no wider significance, no wider consequence. Shadow directorship, then. The judge dealt with the claimant's case that Equity was a shadow director of the claimant companies, paragraphs 299 to 311 of his judgment. If I might ask you to turn that up, so obviously call 7 at page 153. My lady just has been happy. So, as you will see, the judge began by reciting the statutory definition of shadow director in force at the relevant time, so under the 1985 Act. Accustomed to act are words that bear highlighting. A claimant alleging that someone was a shadow director needs to prove a pattern of conduct. A one-off does not suffice. One direction or instruction does not a shadow director make. Paragraph 300, as you'll see, the judge summarises the claimant's case. In 301, the judge acknowledges the conceptual possibility of Mr. Brown taking decisions in one capacity, i.e. as an employee of Equity, and then giving those instructions to himself in a different capacity, i.e. as a director of the claimant companies, to give effect to those decisions. We accepted below. Of course, that's conceptually possible, just seems quite unreal. The final sentence of 301, having admitted or acknowledged that conceptual possibility, the judge concluded that the evidence did not bear that out. That's his factual finding. So, as regard to the sea of evidence, and says, no, that case is not proved. That really was the only case in town on shadow director, save possibly in relation to Mr. Pollard and Ludgate House. But there was no one else who could have been giving directions on behalf of equity to Mr. Brown and Miss Leonard, other than Mr. Brown. Mr. Pollard had no involvement at all in New Court. It's just Ludgate House that he has any involvement in. And there's no direction from Mr. Pollard to Mr. Brown. And even if there was one, and there wasn't, that wouldn't be enough because you need a pattern of conduct. So the judge's factual finding is as unimpeachable as factual findings get. I'm sure my lords, my lady have read it already, but I might just invite you to reread just a couple of paragraphs from 302 to 304, where in my submission, the judge is implicitly accepting Mr. Brown's evidence as to the process that was followed. So in my submission, he's implicitly accepting Mr. Brown's evidence and saying it's supported by the contemporaneous documents. So we have the process followed. It's not a shadow director process. Then at 305, the judge, as he was obviously entitled to do, alludes to Miss Leonard's evidence and says it's helpful, and then refers to a criticism that Mr. Parker, again, continuing his failed arguments below, seeks to run before your lordships and your ladyship. He criticises Miss Leonard's evidence, but in the following paragraph, the judge explains that Mr. Parker's criticism mischaracterises her evidence. The judge accurately summarises Miss Leonard's evidence in 306. For example, she states on more than one occasion that she took her responsibilities as a director seriously and had independent regard to the interests of the company of which she is a director. This is clearly stated to be in addition to asking whether advice had been obtained and had been followed. Mr. Parker, on his feet yesterday, tried to say all she did was check whether there was advice. That's not her evidence, and the trial judge rightly so found. Her evidence in the Angelmas proceedings, she insisted on checking that advice had been obtained, and in addition exercised the independent consideration that she was duty-bound to do. At 307, the judge refers to a practice not just from Miss Leonard's evidence that this practice emerged, but also from Mr. Brown's witness evidence in these proceedings and his evidence on the cross-examination. It was the practice at equity to have one independent director of each company that was in a structure administered by equity. So Mr. Brown was the Ironsar director, in effect, and Miss Leonard was the independent director. I say Mr. Brown was the Ironsar director because he was managing the Ironsar relationship until Mr. Pollard took over. Ms. Leonard's role as an independent director, as the judge says at 307, no doubt was explained in part by good risk management reasons. And then the judge says, if it were expected that the board would simply sign off on any proposal put to them without any independent thought or decision-making, this process, the process of having an independent director, would of course be completely pointless. It would. It is, in my view, appropriate to infer from this that it was not expected by Equity Trust that the directors would simply follow directions or instructions from the administration team and sign whatever was put in front of them. So that's a further justification for the judge's rejection of the shadow directorship case. It's also a relevant finding when we come to look at his rejection of the vicarious liability case. The employees of Equity, when they were acting as directors of the claimant companies, were not being told what to do by Equity, were not expected to do what they were told by Equity. Those are the judge's factual findings. And those are not factual findings that are open to challenge on this appeal. At 308, the judge refers really en passant to Mr. Brown's evidence that he and Miss Leonard had on occasion rejected proposals put to them in their capacity as directors. I say en passant because, as the judge goes on to say, there's no documentary evidence supporting this. Mr. Brown did not give any specific examples, I interpose. Miss Leonard wasn't there to give evidence. And so the judge says, I do not therefore place a great weight on Mr. Brown's assertions in this respect, given the time that has passed since he and Miss Leonard were employed by Equity Trust. Perhaps there an oblique reference to self-enhancing recollection. He's doing the job of a trial judge. He's saying, this was the evidence, I don't give it very much weight. I don't reject it outright, but I don't give it very much weight. But it goes into the balance. He's not plainly wrong to put it in the balance. He's not plainly wrong to give it not too much weight. He's entitled to give it some weight. It all goes to reinforce his conclusion that this just is not a shadow director case. 309. He accepts at 310 the submission by my learned friend Mr. Parker that the directors were not proactive in the management of the companies in question. They weren't telling Equity what to do on the administration front. That's quite right, that wasn't how the structure worked. The administration team worked up a particular transaction and then presented it to the directors. In a much simpler corporate structure, that's also what happens. The back office or mid office staff work up a transaction and then they present it to the board for the board to decide whether to do it. That doesn't make the people who work up the transaction de facto or shadow directors. The chain of command was running the right way here. And the judge really makes that point at 310. Whilst I accept that this is how the system worked, i.e. the transaction be worked up and then presented to the directors, it does not follow that the directors, when presented with the proposal, would accept it without any independent thought. That's obviously right. I'll try to avoid continuing to say that was obviously right. I don't have to show my lords and my ladies that the judge was right on factual findings. I just have to satisfy you that he was not plainly wrong on his approach to facts. So, yes, transactions were presented to the board, but it doesn't follow that they just rubber stamped. And then I see my lords, my lady reading on. I wasn't going to emphasize any other aspects of 310, although I would invite you to reread them. It's about Mr. Brown's dual role and the fact that he was the one running the administration team at Equity, responsible for the iron relationship. So there's more artificiality in suggesting that he was telling himself what to do and then blindly following his own orders. And then 311 is really a reiteration of the judge's earlier rejection of the claimant's factual case, the claimant's case that equity was a shadow director. Explicit rejection, applying the right legal test, not accustomed to act in accordance with directions or instructions given by Mr. Brown or Mr. Pollard on behalf of equity. Instead, they were presented with proposals which had to be justified and in respect of which they gave independent consideration and made their own decisions. That is unimpeachable as a finding. If my lord and my lady are with me on that, that's an end to the shadow director challenge. If we might then return to ground 23, just before the short adjournment. So call 1, page 29. And I'll perform this cross-check in relation to de facto directors as well when we come to it after the short adjournment, but just whistling through the sub-grounds in respect of what is a factual challenge. 1, well, that was no part of the judge's reasoning in concluding that equity was a shadow director, as we've just seen, so that can be crossed through for shadow director. 2, I'll need to come to it in relation to the de facto director question, but again, involvement in day-to-day management doesn't make you a shadow director. That's conflation of shadow director and de facto director writ large, so you can strike through that for shadow director. 3, well, yes, but I've dealt with that going through the judgment. Correct references to 309. I'll come to 316 when addressing de facto directorship. As I've said, it doesn't follow that the system worked from the fact that the system worked the way that it did, that directors just rubber stamped. 4, there was no finding by the judge that Mr. Brown in any respect consciously preferred equity's interests to those of the claimant company. It's just more rerunning arguments they lost below. It's bare assertion by the claimants. And further, in any event, a de jure director preferring the interests of the person X when acting as a director does not constitute X a shadow director. The only thing that can do that is being accustomed to act in accordance with the directions or instructions of that person. I'll return to the bare and bad assertion of conscious preference of interests in relation to vicarious liability. Sub 5 I've dealt with already. Sub 6, the claimants may wish to contend that those matters were neutral on the point of whether equity was a shadow director. The judge did not so regard them. The appellants would need to show the judge was plainly wrong in the way he approached those matters. He was no such thing. And 7 is another example of re-arguing a lost battle. There is no basis for interfering with the judge's analysis of Miss Leonard's evidence in the Angelmas proceedings, which the appellants haven't even put before this court. For the reasons I've given, the judge's conclusion that equity was not a shadow director was very far from perverse, nor was it based on or infected by any overlaw. It should be left undisturbed.
And that, I assume, is a convenient moment.
If it is for you.
2 o'clock.